So, Aaron, I've been reading so much lately about getting one's affairs in orders. What does that actually mean?
Well, I'm happy you asked that, Kathy. It can mean a lot of things to a lot of different people, but from a legal standpoint, I think that's talking with an attorney who does estate planning, and estate planning can be as simple as preparing a transfer on death instruments, or an all going all out and preparing a trust. Now, there's different types of trust, but for the simplicity of this segment, I think we'll just keep it to a revocable trust. So, a transfer on death instrument, which we'll get into in a little bit, is a way to make sure your property transfers to who you want when you're no longer with us, or a trust that administers your estate, can give away a home, can make sure your retirement accounts are passed out to your beneficiaries, who you want to have your property when you're no longer with us, and we'll make sure that your estate doesn't have to go through probate and a judge determines what happens at the time of your passing when you're no longer with us.
Wow, that sounds great. So, I need to make sure, it sounds like I need to make sure all my bank accounts have direct beneficiaries. And what about a transfer on death deed? So, my property gets transferred as well when I die. And how do I get that done?
So again, with a trust, the trust is also going to make sure that your home can pass outside of probate. It can also make sure if you need a guardianship that that's taken care of for you. With the transfer on death instrument or deed, as it's also referred to, if you do a trust, you won't need that. But if you don't do a trust, we can make sure that if we prepare that deed for you, it gets prepared, recorded with the county recorder, and then it's just like preparing a quitclaim deed, except it's totally revocable. And let's say you give it to your son or daughter, and then you decide you don't want to do that anymore. Now you want to give it to a charity or different family member or friend. We revoke that before the time of your death. And Illinois changed the law not too long ago, and now we can do that at any property rather than just residential property. So it's a very inexpensive way to do this. There's some recording charges that the county sets for that, and there's our attorney fee, and that's it. It's a very small fee compared to a will or a trust. And
Wow.
then as
Okay.
far as your beneficiaries, um, we can talk more about that, but simplistically, you just notify your financial institution of who you want to be your beneficiaries, and there's forms you fill out. But if you do a trust, we can transfer assets into the trust.
Wow. Okay. This sounds good. All right. So, living will versus power of attorney for healthcare. What's the difference?
So a living will, which some people sometimes mistakenly think is a last will and testament or are the same thing. A living will is a document. There's forms that you can fill out yourself. I wouldn't recommend that. But it lets a medical facility, a doctor, know these are how you want your last wishes taken care of. You don't want to be in pain or what they should do. It gives them a set of instructions. The power of attorney for healthcare or durable power of attorney is going to give an agent, so it could be a family member, a friend, whoever, the right to act on your behalf when you cannot act. And that is good while you are alive. Once you pass, the power of attorney can include a provision that allows for your agent to conduct an autopsy. But once you pass, the power of attorney is no longer valid.
Got it. So, what is a durable power of attorney? Is that different?
No, that's the same thing. The durable power of attorney is just giving your agent the right to act on your behalf. It's durable.
So, how important is it to have a last will and testament? And I think you mentioned that maybe I shouldn't create one of my own from an online service. And what if I move to another state? Do I need a new one?
So you certainly can create a will on your own. I'd be very hesitant to do that because if you don't have it signed correctly or meet all of the state's requirements, then it will not be valid. There's multiple online services. There's very famous financial people on TV that talk about buy their kit or use a $39, $100, $200 service. Wills, yes, there is a cost if you hire an attorney, but it's just like anything else. You'd be surprised that they're really not that much more expensive just to hire an attorney to do a will. and you get what you pay for. So if it's not done correct, what I advise clients is you will wind up paying for it in the end. You're no longer here, unfortunately, but your family will be the ones who wind up paying for it in the end, and it's going to cost more to go to court than to have had that will done. The other thing you should keep in mind is with a will, that is a set of instructions to a probate court. That's how I like to explain it to clients. That does not keep you out of probate court. We can do another segment on can I sell my house with a will if I pass versus not having a will or versus having a trust, which is a question I get all the time. But the will is a set of instructions. If you have no will, you are definitely going to probate court. If you have a will, you should be going to probate court. And if you have a trust, theoretically, we're not going to probate court. Everything can be taken care of outside of court unless somebody's challenging it. So, and if you move to another state, the answer in short is no, you shouldn't need another will. However, if everything was done correct, you're probably protected. If not, you may need another, you may have issues. So talk to an attorney in the state where you are. Make sure you hire a competent attorney.
Got it. Wow. Okay. So this all seems like a lot. And I also read that I might need a funeral planning declaration.
Very good. That's a good question. So in the trust that we put together, we have burial instructions. You can let us know how you would like your wishes, how you like your wishes to go. Do you want to be buried, cremated? What instructions do you want to give a funeral director, the funeral home? There are people who buy funeral insurance. You can have that transferred into the trust. Maybe you have a funeral plot that you paid for. You can have that transferred into the trust. So all these things can be done. Hire a competent attorney and they'll make sure that it's all taken care of.
Okay. So I also read that I need to have a list of all my accounts, all my credit cards, utility bills, all these things, and somebody needs to have a password access. And don't bills automatically stop when I die?
So bills do not stop. Unfortunately, that is a part of life. Creditors do want to be paid. So, one of the things is now a lot of accounts have two-factor authentication. So you want to make sure that somebody, one, has access to your phone. So I'd make sure that if it's a thumbprint, that's going to be kind of hard to have access to. Make sure they have or fingerprint, make sure they have your password to your phone. If it's facial recognition, that's also going to be hard. So make sure there's a way that somebody can get into your phone to do two-factor authentication. Make sure they have your username and password to your email account. Make sure they know which account goes to which email and what that password is. Make sure they know your online account numbers and two-factor authentication information. Have a binder with that information. One of the things I'll tell clients is copy your statements and put it in a binder with your trust documents or will documents. If the estate is under $100,000, you could use a small estate affidavit in Illinois to close out accounts. Best to have a trust. Your estate's going to have the least amount of headaches. But yes, you want to have an account book that you can leave with your documents for who's ever going to administer your trust or who's going to be the executor of your estate. That's the best way to go. However, you need to make sure you keep it current because if you're like me, you've probably gone, your password's expiring in 3 days, change it.
Ah, very true. All right. So what about titles? So title to vehicles like cars and boats and campers. What happens when we die? Right?
So if you have all the correct documents in place, your executor or your administrator, your successor trustee, they can go ahead and sign everything away, sell the assets on behalf of the estate, or the successor trustee on behalf of the estate can go ahead and sell those assets. If the estate is worth less than $100,000, Illinois has a small estates affidavit that you can fill out or the attorney can for you, and you can use that to transfer title to a vehicle. Now, mobile home is not titled. You don't have a deed to it like a piece of real estate. It's not real property. It's still a home. It could be a home to you and I. There's nothing wrong with that, but it gets a title, excuse me, a title to like a car or an RV. And so there's an annual fee for that you pay, and you usually don't own the land too. Now, some people may own the land, but you're going to have to sell that, and then there's probably a mobile home park that you'll have to deal with to figure out how you're going to pay them rent or be able to transfer the land to the next person or lease. But that's a totally separate issue. But it does get a title like to a car, and that would probably be dealing with the Secretary of State's office, not your county recorder's office.
Oh, okay. So you mentioned a trust a few times. So what is it and how does it protect me and my heirs?
So what a trust does is it takes all of your assets, and it puts it into this very long document, and then you for a revocable trust. So think of the trust as a separate entity. We take everything you have, put it into there, and then you can revoke it at any time. And we deed your home into there. We transfer your checking account into there. We got to fund it. So one of the ways we do that, we could throw your home into it. Now we deed your home into the trust. We can put your retirement accounts, brokerage accounts, anything else you like into the trust, and the trust owns it, but you control it because you're the trustee. And then, unfortunately, when you or your spouse or whoever else are the trustees pass, their successor trustees, and then they will go ahead and sell the assets or give them to, transfer them to whoever they're supposed to be transferred to. Also, if you unfortunately become disabled, instead of getting a court appointed guardian, it can list out who you want to be your guardian. And then also, if you have minor children, just like with a will, you can do this through a will, but it's better to do it through a trust. If you pass, we can have somebody take care of your children. And we can go into more detail once you reach out to me. But in a nutshell, it steps in place of the court and it sets out everything you want done. A will can't do that. It still has to go to court.
So I have a trust. Do I need anything else like a will?
So there is a will that's part of the trust. It's a pour over will. If something was missed, it's going to catch that and the trust will take care of it.
So is there anything else that you'd like to share about future planning and is often referred to as estate planning?
So yeah, so one of the things we're going to do is we'll give you a very lengthy questionnaire to fill out. We will go through that with you, put together your documents. It's going to include your power of attorney for healthcare, finances, a living will, your last will and testament, um, multiple other documents. If you have minor children, we're going to make sure they're taken care of. It's going to give a power of attorney to whoever you want to be their guardian, unfortunately, if you're no longer here. So they could act as if you were acting for your children, make school decisions, financial decisions, healthcare decisions. There's our trust on average are about 130 to 175 pages for a married couple with children. So it's a lot of documents. And also, one of the things our trusts do that I know a lot of trusts do not is if you have a business that requires a specific license. So, for example, in my case, my wife can't go in and do anything other than close down the business. She's not an attorney, but we put a special provision in there that allows that. So, if you're in a special regulated licensed business, we can put a clause in there that if the spouse is not, or whoever's acting on behalf of that person, your successor trustee can go in and close down the business, but they're not going to be able to operate it. So that's important that you have that taken care of for you.
Wow, Aaron, this is enlightening. We're going to have to schedule a follow-up for all of this because I'm
Yes.
going to come up with a lot more questions. So thank you.
Yes, you're welcome.
So, Aaron, I've been hearing a whole lot of things in the news about zombie properties. What are those?
I'm happy you brought that up. I also saw a segment on that recently in the news. So this is a great topic. So a zombie property is essentially, let's say that somebody's gone into default and they're going to either one, surrender the house to the bank, or two, they're just going to leave the home. They're not even going to deal with it anymore, unfortunately. Or a court has entered a judgment of foreclosure. The house has been sold. Somebody's bought the home at the sheriff's sale, or the bank's bought it back. And so the person no longer owns the home, and now the bank, unfortunately, has not recorded the deed with the county recorder's office because Illinois does not have a law requiring that. And so now fines and other things are happening with the property. And so, well, that was in the news segment. Fines are happening with the property and people are getting stuck with it. But short answer, a zombie property is the person has moved out of the home, they're no longer there. And so the home is abandoned now.
So how do you make sure that that deed is now registered to somebody else?
So unfortunately, now that you no longer own the home, the onus is going to be on the prior owner to contact the new owner, which you can go to the county recorder's office or reach out to an attorney, and have them go through various, go to the county recorder's office or go through the title company that they use. There's a way to look at online records or contact the bank's attorney's law office and make sure they get that deed recorded. Because until that deed is recorded, you are still the owner of public record. And when fines are assessed or violations, notices, tickets, all that is going to be against you, even though there's a court record that says now the bank or the new owner who bought it at a sheriff's sale is the owner. That's in the court record. That's not with the county recorder's office. That deed hasn't been recorded yet.
So if they never record it, I'm going to be responsible.
Correct. In the news segment that I saw, there was a woman whose father had a vacant lot, I believe was in the city of Chicago
Mhm.
from 1959. And she had a $650 ticket recently from the city of Chicago for weeds that weren't cut down. And she had to hire an attorney to get rid of the ticket, which I'm certain was more than $650. So, from an economic standpoint, it's hard to fight City Hall. Holly would have paid the 650. It's unfortunate. She shouldn't have had to deal with that. But that is the law right now until the Illinois legislature changes that.
Wow. Is there anything else we should know about zombie properties? Because I'd never heard of them before the news segment.
So I have heard of them before. Clearly, I'm biased here. I'm an attorney. I've heard of this, but there's really not much you can do until, unfortunately, if you're in that situation where you're, foreclosed on because nobody wants to go into foreclosure, you become sick, disabled, can't pay your mortgage payment. It's unfair that you have to go and follow up with the bank's attorney or the new owner, but you have to make sure you do that. And if you don't do that, just like one of the people in that segment, they had their wages garnished, and then they had to go retain an attorney, and that's the way the law is in Illinois. So, the old saying, "Contact your legislature." It's true. People have to band together and now start requiring the legislature to do something. I think it's becoming more prevalent because the state of Illinois is unfortunately hurting for money.
Yeah, I heard that too. Well, thank you for helping me figure out what zombie properties were and if it ever happens, what I should do about it. So
Yep.
thanks.
If anyone needs more help or information, they can contact both of us, and I'd be happy to go over that more with them.
Okay, thank you.
Yeah, you're welcome.